That's a great question, and I have started to think about that because my son is in college. He's 19 years old. So the thing to think about when you're dealing with your children is once they turn 18, they're adults. Okay, you are no longer their guardian, and you lose a lot of statutory rights like access to their medical records in some situations, the ability to act on their behalf in some situations. So whenever I have clients that have adult children, I do sort of it's a little bit smaller package. I usually don't include the will because typically an 18-year-old, 19-year-old is not going to, unless they own a bunch of real estate, I don't really recommend doing a will. It's a good idea, but not something I would consider absolutely necessary. I do recommend a statutory durable power of attorney. So if something happens, you're going to be allowed to pay their bills. You're going to be allowed to interact with their bank and use their money to pay their bills or take whatever action you need to financially on their behalf. Medical power of attorney, same thing. You are no longer their guardian. You no longer have the ability just to make decisions on their behalf like you did when they were kids, okay? They are now adults, and so adults need to designate someone to make those decisions on their behalf. Same thing for the directive to physician. They're going to be the ones that's going to have to make that choice. They're going to have the ability to make that choice now. Same thing for the HIPAA release. If they're an adult child or they're an adult, then they're going to need to designate someone to have access to their medical records. And now under certain state statutes, a parent even of an adult child is going to have access. But again, why make hospital staff have to think about that and look it up and determine those things when you can just hand them a piece of paper that gives you that ability?